So how has this philosophy impacted the unauthorized, what we call the unauthorized expansion of the 4D program? The biggest question is who falls in the at-risk group of 4D recipients? We talked about so far that it means those that would fall on public assistance if they didn't get their child support. And we've also said that the DHS thinks everybody must fall into that class. But I hope that we can agree on this, that Kathleen Blatz, as a divorced person, did not become at risk of falling on public assistance just because she got divorced. I hope we can agree that Susan Gertner, just because she got divorced, didn't mean that she was going to fall on public assistance. Same thing with Pat Anderson, our state auditor. Does she need Title 40 welfare services? I hope that we can agree none of those do. Also, add some more. Alisa, Rockefeller, Dayton, when they were divorced, did she need 4D welfare services? Did she need the government to come in and make sure that child support was received from Senator Mark Dayton? What about Michael Jackson? You know what? He's a custodial dad. He could go to the California DHS office, fill out an application for $25, and have the government go after his, what was it, ex-housekeeper who's now a maid in a hotel to get child support for him. According to the Minnesota DHS, that would be a requirement of the DHS. So we're trying to get to that at-risk group and who should be on this program. Now the Minnesota DHS will tell you all these people. They have to provide services to all these people if they filled out an application. Well, no one's stopping anybody from filling out an application, and the DHS is saying, you know, when you say, why are you doing this? Why do you provide these services to everybody? They say, the feds make us do it. Well, you know what? Absurdities in law must be questioned, and I think we've learned that lesson from Rosa Parks. I was listening to some of the coverage on Rosa Parks, of course, over the last few weeks upon her death, and there was some recordings from her when she was booked and charged. She looked at the police officer and said, "Why are you doing this?" And he looked at her and said, "I don't know, but that's the law." It's that same sort of absurdity and that same sort of challenge that we need to have, and those eyes that we need to have as we look at the Title 4D program. The United States case law is clear too, that the role of the judiciary in cases of this sort, going back to '67 when all this was going on, begins and ends with assuring that the commissioner's regulations fall within his authority to implement the congressional mandate in some reasonable manner. Well, the Supreme Court is making that decision. That also is true for legislators as well, because if the agency is carrying out a program beyond its reasonable manner, beyond congressional intent, it's time to challenge that. And the reason it needs to be challenged is there's some huge misunderstandings taking place. In December of 2004, we got a letter from Kevin Goodnow, who I'm sure he probably didn't write the letter. Somebody on his team wrote the letter. But in that letter, it says, Title 4D is an entitlement program available to anyone who applies for it. So we did some research. Where, looking where is this 4D an entitlement program? In our research, we found out quite differently. I was going to bring the U.S. Code book today with me, I forgot it, but in the U.S. Code, it says clearly that Title 4A of the Social Security Act is no entitlement. There's no individual entitlement. So you would guess that if people, low-income people on need, there's no entitlement. Why in 4D? It makes no logical sense that 4D would be an entitlement program. So we did some more research to find out if that theory was true. A U.S. Supreme Court case, Blessing v. Freestone, makes a very clear statement. It says that the Title 4D program was not intended to benefit individual children and custodial parents, and therefore it does not constitute a federal right, and far from reaching an individual entitlement to services. And it goes on to say that it does not give rise to individual rights. So for us, that made it very clear that Title 4D is not an entitlement program. But we did some more research. In that research, we found a GAO report from 1995. In that report, it's very clear. The rate at which child support services are being subsidized appear inappropriate for a population that Congress may not have originally envisioned. They're talking about the 4D program here. Also in that report, the non-AFDC child support program, many are not within the low-income population to which Congress envisioned providing child support enforcement services. The purpose of this study was to look at that program, and they found out that the program was being broadened. They had broadened the scope to what was intended. I called the GAO. I talked to the woman in charge of these programs. She told me they reported this to Congress and that they still today stand behind this report. But we didn't stop there. We kept digging. And we found a quote from Donna Shalela from the US DHHS, who said, as part of that whole Blessing Freestone lawsuit, that a guarantee of the full range of child support services for all individual cases would bankrupt 40 agencies across the country. I guess you could call her a prophet, because that is what is happening today. We've looked at 8 county budgets in the metro area on how they're paying for these 40 services, because the federal government, the state government has to balance their budget. The federal government doesn't have to balance their budget. The state doesn't have to balance their budget like the federal government does. The counties have to balance their budget. So what we found, for example, in Hennepin County in 2002, they had to do a $5 million tax levy just to pay for this program. And I could give you details on other counties. We can search through your county for you if you want to know the information. Let me know. Then we found some more information. There's a brief written by Ken Starr when he was the U.S. Solicitor General, and there he was talking specifically about the 4D program. The 4D program was designed by Congress to save federal and state funds, what I told you before, by recovering assigned support payments from absent parents of children and families receiving AFDC benefits, and to reduce the number of welfare recipients, consistent with what I've told you. Ken Starr says this plan would be undermined if Title 4D became an entitlement program, which guaranteed specific child support and services to all individual AFDC recipients. So here he's saying that the services are not even guaranteed for AFDC. Why would they be guaranteed for non-AFDC? You've got to ask yourself that question. Then it was interesting, there was also some testimony on file to Ms. Fry, who at that time was the chief of the Office of Child Support in California, testified in front of the U.S. House Ways and Means Committee in Washington in 1997, and she was incredibly frustrated because they were coming out and revising all of these incentive programs for Title 4D. And she's like, wait a minute. You know, the proposals here for these incentives are crazy because it's encouraging states to recruit middle-class families never dependent on public assistance and never likely to be so, recruiting them in their programs to maximize federal incentives. And she went on to say that her colleagues across the country have been talking and informing her that the way to win at this system, meaning the 4D incentive system, is to recruit the middle class so that you can bring in the higher orders into the system and get more money in your state. So when people say it's all about the money, it's not so much all about the money between the mom and the dad. With regard to the 4D system, it's all about the money for the agency. The U.S. House Ways and Means Committee, in their book, acknowledged Ms. Fry's testimony, and in their Green Book, if you're familiar with the Green Book, it comes out about once every 2 to 3 years where they analyze all of the programs. They made it very clear in there that they know the 4D program may be recruiting more and more cases from the private sector, bringing them into the public sector, providing them with subsidized services, but not greatly improving overall collections. So they know this is happening. They know it's a problem. And yes, we have contacted many people in Washington about this issue as well, and will continue to do so. So I've given you many sources about what are the limitations of the program, and is it an entitlement program or not? I've given you all of the following, and we have more if you need them as well.